Law Society's Continuing Education Department, and I'd like to welcome you to this afternoon's program, Case Management Updated. I'd like to take the moment to thank today's faculty for coming here today to speak to you and for their time and very extensive effort in preparing the materials which you have in your binders. They're hot off the press. You're getting the most up-to-date information on this topic that there is available. There's a few administrative matters I have to deal with. The first is that this is a non-smoking facility. If you'd like, as is the whole city of Toronto pretty much, anyways, if you'd like to smoke, you have to do so outside. We'd suggest through the east doors that you entered into this afternoon. There's 3 telephones that are available for your use downstairs, and the men's washrooms are located there as well. The easiest way to find the ladies is through the brown doors and downstairs from the reception area. As well, we have a telephone message facility which is located adjacent to the the registration desk, and we'd ask you check there for little pink slips from your office or your secretary. Inside your binders, there's a gray sheet, which is an evaluation form, which we rely on heavily. We review them all. We would appreciate it if you would take the time to complete that form and give us your opinion of this program. In addition, for those of you who happen to have colleagues who were not able to make this afternoon's session, we know that notice was relatively short. I'd like to remind you that we will be presenting a video replay of this program on March the 20th, starting at 9 a.m. in the morning for the lawyers program and 1:30 in the afternoon for the clerks program. As well, anyone who needs the materials can buy them and an audio tape of the program from our publications department. I'd like to now introduce to you the moderator of this afternoon's program, which is Kevin Aalto. Kevin specializes in corporate commercial litigation with an emphasis on insolvency litigation. The balance of his practice covers civil and commercial litigation on a wide range of problems faced by both corporate and individual clients. And the reason he's here today acting as moderator is that he is a member of the Case Management Operations Committee and has been instrumental in getting this program underway. So with that said, I'll turn the program over to Kevin.
Thank you, Laurel. Members of the judiciary, ladies and gentlemen, welcome to this update program on case management. We are, those of us who have been involved in case management for a number of years on the operations side, see this as a new watershed in that the Toronto area is now looking, or will very shortly be moving to 25%, and the impact on individual lawyers and lawyers' practices will be noticeable. Fundamental to the case management system is the concept that there should be ready and reasonable access to the justice system without undue cost and without undue delay. And case management, although it has been with us since 1991, it seems longer than it is. It has only been 10% in Toronto. It has been 100% in Essex and Algoma. As of January 2, Ottawa began a 100% case managed program, and as I indicated, we will shortly be moving to a 25% amount here in Toronto. Each of the 3 elements of our judicial system, the bench, the bar, and the Ministry of the Attorney General, all have a vested interest in ensuring that the system works. And with that in mind, we are pleased this afternoon to have a cross-section of individuals, both from the bench, the bar, and the administration, to speak about the new case management rule, Rule 77, the changes, how it's been streamlined. It has been streamlined from what we have learned in the last 6 or so years of the pilot project here in Toronto. And it has been simplified, and our guest speakers today will be talking about how to use the case management rules effectively. I should indicate to you that this case management idea is not a phenomenon that is new, that is unique to Ontario. Many jurisdictions in the United States have utilized case management for a number of years. And some of you may be familiar with Lord Wolfe's report. Lord Wolfe in England was appointed by the Chancellor to look into and determine a more expedient way of of moving cases forward in the English bar. They were experiencing extraordinary delays and extraordinary cost. As well, in Ontario, you will know that the Civil Justice Review completed their report last year, and we are pleased to have with us this afternoon the Honourable Mr. Justice Blair, who was a co-author of that report. Among the recommendations in that report is the impetus that case management has had and the effect that it has had on the practice of law in this province. And while we had anticipated that we would have with us this afternoon Regional Senior Justice Lang to offer some comments on the judiciary's view and the involvement of case management and the development of case management. Unfortunately, Madam Justice Lang has another engagement that she could not avoid and is therefore unable to join us. Mr. Justice Blair, however, has gladly stepped into the void and has agreed to speak a little bit longer and add a number of additional comments to those which he was going to make. And as you may know, that Justice Blair practiced civil and commercial litigation for many years prior to being appointed to the Ontario Court of Justice General Division in 1991. He sits frequently in the commercial list, and as you will know if you are a regular attendee at the commercial list, he is a guiding force behind the development of the practice and procedure that is followed on the commercial list. He is also a strong supporter of case management. Justice Blair was the co-chair of the Ontario Civil Justice Review, and that was a joint initiative of the Ontario Court of Justice and the Government of Ontario to review the entirety of the civil justice system in Ontario. I was joking with Justice Blair beforehand that perhaps I should introduce him as the Honourable Mr. Justice Blair Lang, given that his co-chair on the Civil Justice Review was Sandra Lang of the Ontario Ministry of the Attorney General. And I would ask you to welcome Justice Blair this afternoon. Thank you.
Thank you, Kevin. I don't propose to be too long. I must tell you that I spent the first several months of the exercise of the Civil Justice Review reminding myself every time I referred to my co-chair that her name was Sandra and not Susan. Now I find myself here standing in for the Regional Senior Justice Susan, and I'm going to have to go through this exercise all over. I think Regional Senior Justice Lang regrets that last-minute change in her scheduling prevented her from being here, and she asked me simply if I would pass along to you her thank yous for coming and her best wishes in your endeavors in dealing with the case management system as it expands in Toronto and across the province. I want to thank also the Law Society and the CBAO for putting on this program. This is an important initiative which will affect all of your practices, and so it's necessary that we all work together to make it work well. We are, as I'm sure most of you know, currently awaiting the appointment of a case management master in Toronto. That has not been done yet, and the rollout of an expansion of case management is somewhat connected with that event. Probably some of you, if not all of you, are aware that the first case management master has been appointed, Robert Baudouin, in Ottawa, but we're awaiting the appointment of the Toronto case management master right at the moment. And we are moving, as Kevin has said, towards the expansion to 25% case management in Toronto. And I can tell you that the Attorney General is most anxious to extend that to 50% and to 100% as soon as he can. In the early part of this century, Dean Roscoe Pound of Harvard Law School remarked that court management and court reform is not a sport for the short-winded. And that's a sentiment that I've learned to identify with, as have many of you and many in the administration and in the judiciary and the bar have in the past little while as we've gone about this court reform exercise. But I've also learned that indeed things can be accomplished to improve the system when there's enough of a will to do so. Although the road to implementation, like the road to Damascus, isn't always one of sweetness and light. Nonetheless, one of the initiatives which can be counted on as a success story is the one that we're here to talk about today, and which can be turned into a permanent aspect, and that's case management. What I've been asked to do is something that really isn't going to help you a great deal. That's why I'm not going to spend a lot of time at it, but rather to give you some background and an overview in order to place the subject of case management in context, and then you'll hear from Madam Justice Kiteley and the others who will tell you about what you really need to know, which is organization and rules and forms and things of that nature. You've heard a great deal in the past little while about the Advocate Society's task force and the Canadian Bar Association task force and the Civil Justice Review. And what those initiatives did, I think, was both to kindle and to capture a readiness on the part of a continually growing number of people in the system, and a combined recognition that major changes were needed, and a willingness to participate in such changes. Some of these changes are quite fundamental, involving broad shifts in attitude and in the culture of resolving disputes, and case management certainly falls into that category. What the members of the Civil Justice Review Task Force were told over and over again as we traveled around the province, consulting with bar associations and individual lawyers, and with judges and members of the administration, as well as holding public hearings in, I think it was 12 cities across the province, was, as Kevin has already alluded to, that it takes far too long for people to have their disputes resolved, and it costs far too much, and that there was a developing alienation and cynicism among people towards the civil justice system. That developing alienation and cynicism stems from an anger about those delays and the costs of litigating disputes. It springs from a lack of meaningful participation on the part of the public in the system, and it springs from a lack of understanding of the system. But it's there, ladies and gentlemen, and it is a deep-seated and growing skepticism and cynicism, and it has to be dealt with. Arising out of all this, though, has come, as I've indicated, a combined will on the part of you, the members of the bar, the judiciary, and courts administration to accept change and to work together towards it. And this has, in turn, created an environment that is more receptive to recommendations and proposals such as those that have been made by the Advocate Society and the CBA and the Civil Justice Review. In the first report of the Civil Justice Review, as I'm sure most of you know, we set out an overall blueprint or vision, if you will, for molding the civil side of the system in this province into shape as we move into the next century, a system that we hope and are confident will offer fairer, more streamlined, more effective, more timely, more affordable, and more accountable and more accessible justice to the public. And the key components of that blueprint, from an overview perspective, are these. That the courts will become dispute resolution centers, adopting what we adopted as a multi-door approach. I think the CBA calls it something else, but it means the same thing. A multi-door concept of dispute resolution and integrating alternative dispute resolution techniques. It will feature as the central aspect of this, in terms of structure, the establishment of a province-wide case management system that will process cases in accordance with prescribed timelines, using a team approach with judges, case management masters, and case management coordinators and administrators. Case management, we believe the pilot projects have demonstrated, will foster the earlier resolution of disputes, a reduction and elimination of delays and backlogs, the allocation of judicial time and master's time and administrative resources effectively, and as a result of all this, reduced cost of litigation. The system that we have put forward in addition to that will also feature, we hope, a unified management, administrative, and budgetary structure with clear lines of authority and a properly funded infrastructure which utilizes modern technology. And let me just say before turning a little bit to case management that some of these things are actually happening. There is much being done in the area of technology. That's not the subject for today's discussion, but steps are indeed being taken by the government to pursue that and to put into place the technological infrastructure that's necessary, amongst other things, for the expansion of case management. What the pilot projects in Windsor and Sault Ste. Marie and Toronto demonstrated to a growing number of participants and to those who evaluated the project was that case flow management works and that it's worth doing provided that it's resourced properly and provided that it becomes the ordinary way of doing business in the system and isn't treated as some kind of extracurricular activity for you, the members of the bar, and for us, the members of the judiciary. In a sense, the case management concept is the central organizational idea or rubric for combining and coordinating all the various elements in the civil justice system and integrating them into an effective whole by transferring the ultimate responsibility for the management of the flow of cases through the system to the judiciary, by providing for early judicial and quasi-judicial intervention where appropriate, by providing for the disposition of all interlocutory matters within the case management system, the deployment and integration of ADR techniques, the utilization of case conferences and settlement conferences, and more particularly trial management conferences, and by the better utilization of all personnel in the system. I think the essential bywords of case management are disposition where possible and trial where necessary. Disposition where possible and trial where necessary. We know from our experience in Canada and in North America, and indeed in the UK and elsewhere, that 95 to 97% of all civil cases settle. We just know that. And I don't think it matters what kind of a seamless and perfect system we have in place. That statistic is going to remain more or less. So what we have to do is design a way to deal with the 95 to 97% of cases that settle without trial or at trial earlier and faster and less expensively, and that's what case management will enable us to do. It requires planning, it requires support, of course it requires resources, it requires clear and committed leadership from the bar and the bench and the ministry. It requires the establishment of standards and criteria, the adherence to time parameters, and the acceptance, as I've said, of case management as the way of doing business on a daily basis. And so what the Civil Justice Review recommended in its supplemental and final report last November was the introduction of a province-wide case management system which will be governed by a single set of case management rules that are already enacted and which you're here to discuss today, which will feature, as I've stated, transfer of the overall responsibility for seeing that cases go through the system in a timely fashion to us, to the judiciary, and will involve the integration of ADR techniques early on in the process, and which will include a streamlined set of mandated timelines for the disposition of cases. And there will only be three major timelines in the system. First of all, there will be a mandatory ADR session within 2 months of the close of pleadings. There will be a settlement conference within 8 months of the close of pleadings for standard track cases and 3 months for fast track cases. And the target is that cases will be at trial within 2 months of the settlement conference. Those timelines are pretty ambitious, but they are doable, we believe. And I want to leave you by quoting the words of Jerry Short, whom some of you may have met. He's a case management guru from the United States and author of the Quindecker Report, which evaluated the 3 pilot projects in Toronto and Windsor and Sault Ste. Marie. And what Mr. Short said was this: case management is not about single acts of Herculean effort, although he may not have talked to Justice Koo when he said that. Though sometimes they are required to take a project over the hump or to reduce the backlog. Instead, he went on, case management is about institutionalizing a process and a support component that has as its first and second concern the fair, just, economic, and timely management of cases. It is simply a way of doing business. Case management is not a pilot project. It's not a buzzword or a fad. It's not a trick to transform judges from experienced, respected jurists into process managers, and it most certainly is not a means to other ends. Case management is, in fact, an end unto itself, says Mr. Short. It is preservation of the most important roles and function of the judiciary. It is ensuring that the public's trust is protected. It is fulfilling the very reason that courts exist. To think of case management in other terms is to relinquish it to a lesser task. To make case management the order of business for all, many things must be done, he says. Foremost is a clear articulation from the bench, bar, and ministry leadership that case management is not a program or project, but it is the regular order of business. To this end, case management must cease being a separate set of rules or procedures. It must indeed be the rules of court, the rules of civil procedure, the standards of judicial administration, or the terms of reference. And in that, I think he was right. And that, it seems to me, is the task and the emerging reality that you're all here today to learn about, and I'll leave you with that. Thank you.
Thank you very much, Justice Blair. Our next speaker this afternoon is going to give us an overview of the organization of case management. And our speaker is the Honorable Madam Justice Kiteley. By way of background, you probably are all aware of the fact that Justice Kiteley is a former bencher. She practiced in the family law area for many, many years. But you may also remember that Justice Kiteley, along with Justice Wilson and Justice Koo, was one of the people that were originally determined that case management was a system that would work and a system that could be adapted to the Ontario court system. And in that context, she was a member originally of the Joint Committee on Court Reform. Before her appointment to the bench in 1995, she was a co-chair of the Joint Committee on Court Reform. She currently sits as one of the team members of the case management team here in Toronto. She is now again a member of the Operations Committee for Case Management in Toronto. She had been a strong and vocal member of that committee for many, many years, and after her appointment, she took a brief respite before coming back on board to assist in the reorganization and the streamlining process that we now face. So she is an excellent speaker to give us insight into the overview and organization of the system. Would you please welcome Justice Kiteley?
Thank you, Kevin. Can I be heard at the back of the room? I'd like to thank Justice Blair/Lang for giving me a few extra minutes because I was going to be daunted to do what I have to do in 15 minutes. My job is to give you an overview of the rules, and it can be done in 15 to 20 minutes, the reason being that what we have in this project is less rather than more. For those of you who've persevered, and many of you are in the audience, since 1991, when the pilot project started, you'll quickly identify from the materials that the timetable of the pilot project rules have been re-engineered, which is, of course, the new jargon. In essence, the pilot project and the Civil Justice Review told us that round one, we overmanaged. And what we're trying to accomplish is intervention with the kind of deadlines that Justice Blair has mentioned. I need to take a moment to explain the rule process for those of you who think it's a mystery. There is a Civil Rules Committee that must approve all rule changes. The rules that were published in the Ontario reports in January are the product of the Rules Committee. There was a timetable that was affecting the passing of those rules, namely the desire in Ottawa to go 100% case management sooner rather than later. Ottawa had actually originally a deadline to start 100% case management in September of 1996, and for a number of reasons it had to be postponed. They were quite anxious, however, to start January the 2nd, and that meant that the rules had to be done in time for the Ottawa project. As it turned out, the rules that were in the Ontario reports took effect February the 3rd, and in Ottawa, the bar and the courts operated as if the rules were passed effective January the 2nd, 1997. Once the rules were approved by the Rules Committee, invoked and in effect in Ottawa, and then as of February the 3rd in Toronto, it became apparent that some refinements were needed, particularly in Toronto, because of the need to still accommodate two systems. See, in Ottawa, they went 100% subject to the exclusions in the rule. So the Rules Committee was asked to consider what I stress are refinements and modest changes to the rules on February the 19th. And if you look at tab 1 of your materials, the bonus you get for coming to this program is that you have a consolidated version of the rules. Those who don't come and don't borrow this from you for photocopying will have to wait until the next version of Watson and McGowan's rules. So what you see here, if you'll look with me, the heading tells you it's Regulation 555, which was what was in your ORs, and then amendments recommended by the rules. And if you go to the bottom of the page where the footnote is, those amendments were approved or recommended by the Rules Committee Feb 19th, and it is a process by which the Lieutenant Governor and Council has to consider them and sign on. The paper for that is expected to be accomplished in early April. What you have at tab 1 does not tell you the changes between the version in effect February the 3rd and the current version, and that is deliberate. Firstly, because the changes are modest, and secondly, because effective now, these rules, the ones you have at tab 1, are the ones that work. The biggest clarification that had to be made in these rules was the notice of commencement of proceedings and notice of defense. And you understandably had lots of questions, which we tried to answer during the process and which we have clarified. So when you take this home, you can forget about this one unless you have an intellectual need to cross-reference one against the other to see what we did change and work with these ones. We're hoping that the bar, having cooperated for the last month when we had some growing pains with these rules, will continue to have that cooperation until the final version gets signed by the Lieutenant Governor. The random selection continues as we speak to be 10%, but as Justice Blair indicated, we are awaiting only the appointment of the master, the case management master. The hiring interviews have all taken place and the recommendations have been made to, I think it's cabinet, and so we're just awaiting the final appointment of that person, and it is anticipated that shortly after that appointment we will be able to have the Regional Senior Justice direct the registrar to increase the random selection from 10 to 25%. I suspect you'll read about it in the paper when that master is appointed, and you can expect commencing literally the day after we get the paperwork organized that the random selection will increase. All right, let me take you now to, also in tab 1, there are 3 charts. If you'll look first at the headings, the first one I'm going to be considering is the Rule 77, cases commenced after February the 2nd, so that's the February 3rd commencement date. The second page is the flow chart, and the third is the transitions. So if you go back to the first, On the theory that almost any case you present can be reduced to 1 page, we reduced it to 3. So we'll see if we can give you the big picture, bearing in mind that those that follow me are going to be dealing with some of the details of it. Now, once we issue the originating process, there are differences depending on whether the case is randomly selected. If you look in the non-case managed side, you issue and file your originating process, as has always been the case. But on the right-hand side, under the case management, you issue the originating process. You don't file your originating process at that point. On the second line, in non-case managed, you file the notice of commencement of proceedings, as you do in the case management, file the notice of commencement of proceedings. Back on the left, you serve your originating process, and on the case managed side, you serve the originating process and the notice of commencement of proceedings. And then lastly, in that box under case management, you give, that's the verb in the rules, you give a copy of the originating process and the notice of commencement to the plaintiff. Now, the role of the notice of commencement of proceedings over the last month has probably generated more questions than any single change we've tried to make recently. We think we have made this as straightforward as possible. You will be the test. Going back to the left-hand side, in the non-case managed, you serve and file your statement of defense. In the case managed, you serve your statement of defense. And on the non-case managed, you file the notice of defense. On the right-hand side, under case managed, you serve and file the notice of defense. Then going to the third part of the case managed box, under filing of pleadings, see, up until this point, you haven't filed a claim or a defense. So if you're randomly selected for case management, you will file your originating process when there's a further step taken, your defense when it's required for a hearing, such as a motion, or when you get a requisition from the registrar that a non-party has asked for the document to be brought into the court office. Now, part of what's going on here has nothing to do with case management. It has to do with records storage. When the government looked at its record storage, it found that it was holding, as you know from trying to get files out of Cooksville or Clarkston, wherever it is, somewhere out there, probably billions of documents. And part of what's going on here is for the court, in the case managed side, to not receive those pleadings until they have to. There are some cases that start and go away. So why should the court have all these statements of claim? They will have one piece of paper, a notice of commencement of proceedings. There are lots of cases that start and there's no defense. It settles or whatever they do. So why should the court have notices of defense? So from a paper control point of view, this was an opportunity on the case managed side to only have the pieces of paper, the pleadings, when a further step is needed, such as a motion for a default judgment, or a hearing, such as a summary judgment motion. We needed to protect the non-parties because under the Courts of Justice Act, there is public access to pleadings, and you'll see in the rules that if a non-party, the media collection agency, somebody who's interested in it, they file a standard form requisition with the registrar and say, I want the statement of claim in thus and so action. The registrar will notify you to bring it in, and hopefully you'll bring it in. If you don't bring it in, the registrar does not have compliance powers, and consequently it will be left to the non-party who's asked for it to seek compliance. Go to the second page, the heading Cases commenced after Feb 2 and selected for case management. So I'm now on the right-hand side of the first chart. Forget the left, I'm off of the non-case managed. All right. There are, in effect, two kinds of branches here. After you've issued your notice of commencement and you've chosen your track on the notice, one of two things can happen, essentially. On the left-hand side, no defense. If that happens, the case will be left all by itself until the big computer in the sky spits out 180 days after issuance. And if at that point the plaintiff, burden is on the plaintiff, you must note, unless the plaintiff obtains a final order or judgment, that case will be dismissed by the registrar. Again, this is a control. We, the court system, have never had a handle on the inventory that's in the court system, because cases start and they wither on the vine. Well, this is a way to end cases. So one of the new things that all counsel should be doing is a tickler system for 180 days and advisably 150 days so that you can do something about it before the 180 days happens. We are optimistic that we don't get a flood at day 181 of requests to set aside registrar's dismissal orders. So we're hoping that that will get built into your tickler systems. All right, let's move to the defense side. Now, there are some cases that would go straight to motions, and that's why the arrow in the middle of the page. Those kinds of motions will be a motion that there isn't jurisdiction in Ontario, because a defendant can move on that before filing a defense. It could be a motion by a defendant that the statement of claim doesn't disclose a cause of action. So those kinds of motions go straight into the motion line. Others, there will be a defense, and defense is defined in the rules, but it isn't just a defense, it's a defense and counterclaim, etc. So the defense is filed, and as Justice Blair was indicating, there will be an ADR component. For now, we've only put the box in. It comes in after defense and before settlement conference. But the rule, yet another rule, the rule for ADR is in the process of being drafted, and so there was no point in giving you any more detail at this point. So assume that the ADR rule, whatever its final version is, has kicked in and been accomplished. We then go to the next line. There could be more motions. There could be a case conference or more than, and you're going to hear from those that follow me more about case conferences. So motions and case conferences are voluntary. They don't have to happen. Settlement conference, on the other hand, the third box on that side, is mandatory. And it will happen if you follow the arrows down to the next line. On the fast track, within 90 days of the first defense, and in the standard track, within 240 days of the first defense. So 3 months and 8 months. After the pre-trial, the settlement conference, I'm still calling them pre-trials. After the settlement conference, there is a new conference included in the rules called a trial management conference. Now, some of you have probably already experienced this animal if you practice in Toronto. In our long trial list, which seems to have expanded, short trials don't seem to exist very much anymore, but anything 10 days or anything more than 10 days is what we call a long trial. And in order to try to have some control over these long trials, we have been doing some voluntary kind of trial management conferences. The forms, as you'll see when you get to them, include a trial management conference form. And these boxes are small, so we have to use short forms. But in that box, you will see that you have to file a trial management conference form, either 14 days in advance of the trial or 4 days before the trial management conference. And so the shorthand has been used in the box. Now, as one of our colleagues on the operations committee, was actually Adam Wagman, pointed out, there should have been another box before trial. And so can I get you to put in a box between that arrow there to file your trial record. Because you get settlement conferences without having been passing your record and setting it down on that list, we find far too often that trial comes up and still nobody's filed a trial record. So the next version of this one is going to have its own formal box. But for now, a trial record is needed, followed by the trial. Would you turn to the third page? We needed to consider the cases that were in the system before February the 3rd. And so the last rule in the package is the transition rule, 7717. And there are, of course, two branches to this. You need to appreciate that we have thousands of cases in the system, and to manually try to do something about them was problematic. So the solution that the Rules Committee came up with was this. If you had started before February the 3rd on the left-hand side and a statement of defense had not yet been filed, then the computer is starting the 180 days at February the 3rd. So the plaintiff then still has that burden. There's your tickler system comes in, and so for cases that were in the system before Feb 3rd, you should probably be going back to your office and adding the 180 days to that. Again, unless the defense is filed or the plaintiff obtains a final order or judgment. Now, on the other hand, the statement of defense filed before February the 3rd, this will end up with 365 days starting to tick on February the 3rd. So this is your other tickler. And it will be dismissed February the 2nd, 1998, unless the parties, underline the parties, have fixed a settlement conference. You have to take the initiative to do it. When moving from a 10% system, which was heavily managed, as I said earlier, to a 25% system, which is less managed, it became quite a challenge to find those cases that didn't have a settlement conference and schedule them. So the only way around the problem was to put the burden on the lawyers. You know what files were pre-Feb 3rd and which hasn't had a settlement conference. So those need to be brought forward, and I wouldn't wait until 360 days to start doing this. I would identify those soon. We have some months before you can have a pretrial, and so I would be getting those organized sooner rather than later. So that is the new rule in 3 pages. If you'll go back to the text of tab 1 where you find the rule itself is you have 2 sets of page numbers. If you use the page numbers on the right-hand side of the page, the text of the rule is 15 pages, followed by from pages 16 to 25. Again, on the right-hand side of the page are the forms, and others following me will be talking about these forms. Would you turn, in the few minutes I have left, to tab 2? Part of my task was to talk about the organization of the judiciary, etc. This summary is intended to focus on who can do what. And I won't walk you through it. There are several categories. The first is general powers and the creation of the case management master. The second is a failure to comply, and as between the judge and the master, who can do what. Now, essentially, the master will be doing what masters can do under Rule 37, plus management functions under this rule. If you turn the page, that whole page is motions, and I'd like to make a modest change under 7711. Sub B and sub F are really the same, so scratch out either B or F, it doesn't matter. That's 7711 sub 1, B and F. On the third page, the case conference, which is a vehicle that we have had for all of the life of case management so far, and about which you're going to hear more. Then the settlement conference, formerly called the pretrial. And on the last page, the trial management powers of the judge and of the master. I want to pause on motions under 7712-15 and the powers of the registrar. The registrar can do an enormous number of things. But in sub 1, they are matters that are on consent, and in sub 2, for an unopposed order. We encourage you to use those rules wherever applicable, and not feel compelled to have a judge's or a master's name on something where the registrar has the jurisdiction to do it. Thanks to Justice Blair giving me a few extra minutes, I've managed to get through what I was supposed to do, and I think we can move to the next phase.
Thank you very much, Justice Kiteley. The next two speakers are going to deal with some detail relating to the forms and the specific elements of various parts of the rules. And I'd like to introduce both Bev Eldridge and Richard Horak to you. Bev is our chairman in point of fact. Bev is a member of the Ministry of the Attorney General. She is the manager of civil intake, and she may describe what that entails in more detail, at the Ontario Court General Division, but she is also the chair of the Operations Committee of Case Management. And it is her staff and team that deal with, on a day-to-day basis, maintaining the paper flow and correcting the glitches that are found from time to time in the sustained computer system that is the fundamental piece of software that controls case management in Ontario. Bev has been a member of the administration within the Attorney General's office for many, many years, and is familiar with all levels of administration within the court system. Richard is a partner at Hughes Amos. He has also participated in case management for a number of years as a member of the Operations Committee. He practices civil litigation. He's a member of the Insurance Defense Bar and has practiced since 1979. You may note in the biographies in the materials that Richard is alleged to have got his LLB in 1997. I can assure you that it was 1977. Richard is a member of the Canadian Bar Association and the County of York Law Association, as well as the Medical Legal Society of Toronto and Advocate Society. And I would ask you to welcome Bev and Richard for their comments on the rules and forms.
Hello, everyone. Can I be heard? Is that fine? Okay. Justice Kiteley and her wonderful charts have taken us very nicely through the notice of commencement and the notice of defense, but I would just like to talk about those two items one more time. I know that there was some vehement discussion, shall we say, at my counter many times around whether the notice of proceeding needed to be filed and served with every case. These rules as they're drafted on February 19th, of course, spell it out quite readily for us. You only need to serve it with case-managed cases in both notice of commencement and notice of defense. So never again will your staff come back from my office and tell you that they've had that problem where we've insisted, because we're not insisting anymore. That change was well, no explanation needed. I'll leave it at that. Please note that the changes that were made on the 19th also include 2 of the regular rules, Rule 14 and Rule 18, and you see that on page 1-7, where it states that you shall, if we take 14011, where it was changed, Rule 14, that you shall file a notice of commencement when the originating process is issued. And over on to the next page, it speaks about defenses, notice of defense, where you shall file a notice of defense when a notice of intent to defend, a statement of defense, and et cetera. I don't need to read you the way through it. You can read it yourselves. It's right there. One of the things I am up here to do is to talk to you and make sure you notice the exceptions to case management. We will not be randomly selecting any of the listed exceptions, and they are the actions or applications to which the Toronto Family Case Management rules apply, actions or applications placed on the commercial list, actions or applications under Rules 74 and 75, and those heard by a state's court, actions or applications under the Construction Lien Act, under the Bankruptcy and Insolvency Act, under the Class Proceedings Act, and then I need to tell you about a couple that aren't printed there, but which are policy exclusions. While Toronto is not at 100% case management, we will not be randomly selecting any simplified rule cases. If you bring in a case that's simplified rule, it will not be case managed, nor any applications of any kind. We'll only be doing statements of claim. There was much discussion also at my counter around the Law Society numbers. On that notice of commencement, we've asked for the Law Society numbers. We facilitated anybody who was at our counter without having them by having the list available. And then we heard some people thought that they were confidential and they should not be given out. They're not confidential. They can be used. They have actually been used in our sustained system for about 1.5 years. It's how we identify you. When you come in now, we'll enter your Law Society number and we have your name and address properly in the program, and we won't get Bob Jones and Robert Jones and R. Jones as being 3 different lawyers, which has been known to happen in the past. Let's carry on through here. Let's see. The next thing I have to talk about, we've talked about the notice of proceedings, the notice of defense. This requisition by a person not a party to the action. Now, Justice Kiteley alluded to the fact that the court will not do anything if we send you the notice that says someone wants to see your pleading, please send it in. And it says in the rule, well, for defenses, it's Rule 7709(5). If you don't do it, 5 and 6 is there, it's on page 1-13. You must do it within 10 days of our request. Now, we know that some of you aren't going to do that for various reasons. And as she said, the court will not be coming after you, but the person who wanted it will certainly be asking for an order, and maybe costs, who knows, you know, anything could be asked for before a justice. I'd also like to mention that electronic filing, you've probably heard that electronic filing is coming. Electronic filing project is going to start sometime in the late spring in Toronto with 102 lawyers and law firms who have identified that they'd like to be in it. Electronic filing can be case managed, so that when we are taking in cases, electronically filed cases, you might find yourself getting a case managed number back. That will happen. Also, at that same time, or briefly before that, we are going to be changing our sustain system. Speaking of technology, our sustain system will be in sustain for Windows, going into the Windows environment. And the program itself will be choosing the numbers. Right now, we randomly select manually by going and getting a case file that has a number on it, and it's every 10th one is case management. But the system will be doing that itself, so life will get a little easier then, and it does know to jump over all the exceptions. So if someone walks in with an estate action, it's not going to end up getting case managed because the program says it must. That won't happen. Now, the transition rule. Justice Kiteley also in her charts there set that out quite nicely. The transition rule, as she said, it's in your ballpark. If you don't do something, you're going to lose it. Now, there will be a notice sent out, and we're in discussion as to what the timing will be on the notice, whether it will be at a 150-day mark or at a 180-day mark. But don't count on us to do it. Please, please make sure that you take action yourself and don't lose your cases and have to do motions because you let the timing go by. The forms, which are start at 123, or page 16 on the right-hand corner. Most of you have probably seen the notice of commencement. It is very much like the one that was published. There are just some minor changes on it, the file and the signature of the registrar, etc. But for the most part, it's the same one that was published. The notice of defense, though, has changed considerably. You turn over to that one. It was in a table form prior to this. Now it's in paragraph form. But this is the one that we are hoping you're going to walk in with. In order to facilitate the use of that one, we will have them available at the counter, the same as the new notice of commencement. We had had a case management information workstation available, and we're giving out the forms for anyone who arrived without them. And I think many of you now have them, though, in your computers and are bringing them in. We'll be giving out the new one, and we certainly, until this is declared in force, we wouldn't refuse to take the old one. The next form that we have here is case management motion. I think at this point, I'll turn over to Richard, who's going to speak about the motions before we carry on with the rest of the forms.
Thank you, Bev. My task today is to speak to you about motions, case conferences, settlement conferences, and trial management conferences. And what I hope to do in the next few minutes is to go through the sections of the rules with you, highlight for you exactly what the rule says, and the speakers that are going to follow me are going to talk in a little more detail about some of the tactical considerations and some of the strategies that you may want to apply for use as the process goes on. My task is to try to educate you as to exactly what these rules say. I thought long and hard of a way to try to make this really fascinating and interesting for you, and unfortunately I don't think there is a way. The only way to do it is to look at the rules and see what they say. So I'm going to have to ask you to bear with me as we go through in somewhat painstaking fashion, just so you see exactly what these changes are. Dealing first with motions, if you turn to page 1-14, Rule 7712 is the rule that deals with motions. Again, many of you will be familiar with this from the pilot project. You'll know that there is an informal motion procedure. Before I get into that rule in detail, there's one transitional rule, if I can call it that, which is important to note. Those of you who have practiced will recall that for some years it's been a rule that motions have to be brought not necessarily in the case, not necessarily in the jurisdiction where the action is commenced, but in the jurisdiction of a responding solicitor. The case management rules change that, and this is an important one to note. If you just flip back to page 1-9, and look at Rule 77.01, sub 5, subheading is place of hearing of motions. This rule takes you out of Rule 37.03, says it doesn't apply to a proceeding governed by the rule. All motions shall be heard in the county where the proceeding was commenced, unless the court orders otherwise. So now you're back to, for those of you who have been around long enough, you're back to where we used to be. You bring the motion where the action was commenced. And for those of you who have lived with some of the problems of dealing with motions in cases where responding solicitors are in other jurisdictions, it hopefully will be a little simpler under these new rules. So that's very important to remember where you bring the motion. Now let's go back to 7712 at page 1-14 and talk about what exactly this informal motion procedure is. The rules, as you know, provide for all sorts of documentation to be filed, but under the case management rules, as you'll see in sub A, a motion can be brought without a notice of motion, without supporting material, and without a motion record, depending on what is referred to as the practical requirements of the situation. That motion can be heard, according to sub B, by conference call, can be by telephone call, can be by fax, can be in writing, it can be by way of an attendance. So if you're going to bring a motion, you initially have to make that decision as to how you're going to bring it and what you're going to do in terms of material to bring the motion. And obviously, that decision is going to be made based on what the motion is all about. Some other speakers may tell you more about that. Sub 2 says that if the motion is brought without a notice of motion, then you use that motion form, which Bev referred to. That's at that's form 77C. You'll see that at page 1-27, and that in effect is a form designed largely to enable you to check off the applicable sections. There are some areas of the form, as you'll see, that actually have to be filled in with some substantive material, but for the most part, it's a check mark type of approach. The moving party has to sign that and submit that if you're using the informal motion procedure. A responding party may submit one, doesn't have to. The case management judge or the master or the registrar, depending on who hears the motion, will record the disposition on the form itself. And if you flip to what is page 1-30 of Form 77C, you'll see that there is a section entitled Disposition by Case Management Judge / Master, and then you have your tick mark as to what's going to happen. And it also, as you'll see on the form, indicates whether or not a formal order must be prepared. The rule itself says you don't need to prepare a formal order or have it signed or entered unless the judge or the master directs that that be done, or unless there's an appeal to an appellate court. So, as I'm sure you can appreciate, for the vast majority of motions, it should be much, much simpler. Now, if there is going to be opposition to your motion, Rule 7712 sub 3 talks about the confirmation procedure. And again, this is in alignment with the procedure which is developed in the last few years in terms of confirming that motions are going to proceed, if in fact they are going to proceed. The rule provides that the moving party's solicitor shall confirm by fax or notice in writing 2 p.m. the day before the hearing date that the motion is to proceed as scheduled. And if you don't do it, the rule says the motion shall not proceed. Sub 4 talks about costs on the motion. The judge or the master shall address the issue of costs at the conclusion of the motion, and where appropriate, fix the costs, order them payable forthwith. Sub 5 talks about the motions to be dealt with by the registrar. Justice Kiteley made reference to that in a general sense in her comments. I'm not going to go through the individual items, but you see they're all listed there as to what types of motions the registrar has the authority to deal with. And the important point to stress, as Justice Kiteley mentioned, subparagraph 1, this is a motion if it's on consent. Subparagraph 2, if it's not opposed. And the other rider, which again applies in both cases and really shouldn't be a problem, is that no party affected by the order is under a disability. We're all familiar with that terminology from the general motions. That takes care of motions. Now I want to move on and talk about the case conference. Rule 7713 deals with the case conference. This can be initiated by a judge or the master on his own initiative, or it can be requested by you. And from my experience, I know that the judiciary would welcome your calling for or requesting a case conference, because it is a good shorthand way to deal with some problems and to, without making the pun too obvious about getting on track, to get things rolling and moving along. Note that the case conference can be convened at any time, so it's not something that has to be done at an early stage. It's when appropriate. When you decide it's appropriate, you can request it. If the judge or the master decides it, they can request it. Note in sub 2 that parties are entitled or maybe requested, the wording is directed by the judge or the case management master. They may direct that the parties attend, and note the wording, or a representative of the parties responsible for making decisions regarding the proceeding and instructing the solicitor. So those of you who do some insurance defense work, as I do, will have to keep in mind what that wording is, if directed or if requested, or if you decide it's something you want to do. They can attend the conference personally. Sub 3 deals with the scope of what can be dealt with at a case conference. And you'll see the wording is fairly general. Sub A, you identify the issues, note those that are contested and those that are not. Sub B, explore the methods to resolve the contested issues. Sub C, if possible, secure the parties' agreement on a specific schedule of events in the proceeding. And sub D, review and, if necessary, amend the timetable for the proceeding. So the scope of matters which can be discussed is, generally speaking, quite broad. You will see the admonition to counsel in sub 4 about those in attendance having the authority to deal with the matters referred to in the scope of the rule, and to be fully acquainted with the facts and the legal issues. Now, what can the judge do? The powers of the judge are set at sub 5. The powers of the case management master are set out at sub 6. And you'll note there are some differences in terms of what a judge can do as opposed to what a case management master can do. I don't propose to go through those in detail. You can read those, but you can see the general idea is to get the timetable in order and get the action moving forward. One interesting aspect is 5E, the judge may convene a settlement conference. Sub 7 talks about simplified procedure actions, and notwithstanding what you just heard from Bev about the practice for the immediate future, ultimately Sub 7 will become important in the case management world, and that simply indicates that if you are in a case with Rule 76, the simplified procedure, then the case conference can only be convened in conjunction with the settlement conference. So again, we're restricting the number of appearances and presumably keeping the costs down. And Sub 8 is, again, from a practitioner's perspective, a very important subsection, because that provides that the judge who conducts the case conference won't preside at the trial of the action or at the hearing of the application, so you don't have to concern yourself with any difficulties you may encounter, positions taken, and so on and so forth at a case conference, because that judge is not going to be hearing the ultimate trial if you get there. And that's all I want to say about case conferences. Now on to settlement conferences, which, as Justice Kiteley noted, we'll be calling pretrial conferences for some time, but that's the new terminology, settlement conferences. As you heard, these are going to be scheduled automatically by the registrar, depending on whether it's the fast track or the standard track. You have different time frames. 90 days if it's fast track, 240 days on the standard track, and that time starts to run from the date the first defense is filed. So depending on the type of action you have, if you've got multiple defendants, that time may run a little faster than you might anticipate. Subsection 2 of 7714 talks about what's to be done in advance of the conference. And basically, the answer is everything. All the examinations for discovery are to be completed. All of the productions are to be made. All motions arising out of the examinations or arising out of production of documents shall be completed before the settlement conference date. And Justice Wilson or one of the other justices may give you some indication later as to what might happen if you get to a settlement conference and some of these things aren't done. The theory, I can tell you very clearly, is all of this stuff must be done, and you must be at a settlement conference, which, again, equivalent to the pretrial conference, ready and able to, in effect, try your case and to discuss all the issues. Subsection 3, the same provision about attendance of parties at a settlement conference that may be directed by the case management judge or the case management master. Similarly, a representative responsible for the decision-making process may be asked to attend. And one interesting thing which is included in this aspect, it's provided that the party or that person may attend all or part of a settlement conference personally with their counsel. So it may be that the parties are there for part of the conference and then are excused, brought back in later. It's a very flexible rule. The settlement conference brief is set out in sub 4 just in terms of a time frame. Again, this won't apply in Rule 76, simplified procedures actions, but other than in that case, the rule provides it's to be delivered by the plaintiff not later than 10 days before the settlement conference. And we'll touch on in a moment what the contents of that brief is to be. The plaintiff, when he delivers that, in addition to putting in all the necessary material, has to certify that everything is done that should have been done as set out in sub 2, and that's all the examinations for discovery, productions, motions that we talked about. So the onus is on the plaintiff to certify that, in fact, everything is ready. All other parties are to deliver settlement briefs, and the rule provides, sub 5, that their briefs must be put in no later than 5 days before the conference. So again, I hope my cohorts will forgive me for introducing a comment from a defense counsel, but it's nice to see the rule providing that the plaintiffs have to provide the material so that the defense and the subsequent parties will respond. That's now clearly set out in the rule. As it now stands, sometimes that doesn't happen. And I think that's very beneficial. Sub 6 at page 119 talks about what the settlement brief is to contain. This is also a very important rule because it's a little bit different from what some of us are used to doing in terms of pretrial material. Sub A talks about a concise summary of the facts, including agreed upon facts and admissions. Sub B, a concise summary of the issues and law to be relied upon by each party. That is similar. Sub C is interesting, a list of witnesses and a summary of each witness's evidence. Sub D talks about the relevant portions only of transcripts, experts' reports, and other evidence that may be adduced at trial. So you can see it's a bit more comprehensive, and the theory is that everything in that brief that needs to be there will be there so that all issues can be fully canvassed at the settlement conference. Now, what happens after the settlement conference? A trial date is set. This is to be done by the judge or the master at the settlement conference, or it can be referred to a judge responsible for the assignment of a trial or hearing date. As you heard earlier, the trial record gets filed subsequently, and again, there's a provision about the simplified procedure, which I don't want to dwell on, and again, there's the similar provision sub 10 dealing with the fact that a judge who presides at a settlement conference won't be the judge hearing the trial. Amazingly, I'm still on time, and I can tell you a little bit about trial management conferences. Paragraph 7715, as Justice Kiteley excuse me, indicated, this can be held on the request of the parties or on the initiative of the trial judge, case management judge, or case management master, and the timing is either 14 days before the trial or 4 days before the trial management conference. This Form 77D, is to be filed. That's sub 2, and I'm now on page I-20. I do want to take you to that form just very briefly. And the Form 77D is at page 1-31. Again, I don't want to steal others' thunder because there'll be others talking later about the material that you are to put in the form. All I want to say, as you look through the form, it's fairly detailed. There are sections for issues, witnesses, experts' reports, and so forth. I'll leave that for others to comment on more detail, but this is not something, I suggest, that you're going to be doing the night before the trial management conference form is supposed to be filed, I hope. Going back to the rules very briefly, at page I-20, or 1-20, subparagraph 3 talks about the powers of the judge or the master. And again, this is set out in fairly broad language. Canvass with the parties the names of the witnesses to be called, the substance of their testimony, explore whether admissions could be made that will facilitate proof of non-contentious matters. Sub C, I find interesting, explore alternative methods of presentation of evidence, such as the filing of affidavits or reports. Sub D, explore with counsel expeditious means for the presentation of evidence. And sub E, give directions that will facilitate the orderly and expeditious conduct of the trial. And this is the part of the program I'm glad to say I don't have to comment on, and I'll leave that for others to comment on as to how that's going to be interpreted. Again, the only other section to refer to here, as you see, is the sub 4 dealing with the simplified procedure, and that provides that a trial management conference can only be convened in conjunction with a settlement conference. So again, everything is going to be wrapped up into one. If you are in a simplified procedure case, you don't have multiple attendances. And that, in a nutshell, is all I have to say about motions, case conferences, settlement conferences, and trial management conferences.
Okay. Just before Richard and I end our portion, the third page in your, just 1, 2, 3, is a list of phone numbers and fax numbers for the case management unit. And may I apologize to the court or anyone who's listening for leaving out the word court. Please take the liberty of putting it in there. We're Ontario Court General Division. Just 1, 2, well, actually, it might be the first page. It really depends where you put your agenda. I put mine right at the beginning. So it's Ontario Court General Division Case Management Communications Network, right near the front. Those are the phone numbers to use, and those are the people's names who are available in that unit to help you. And this will be given out at tomorrow's session as well for law clerks and support staff. If any of your people are coming, they will be getting that as well. And that's it. Thank you.
Thank you, Bev and Richard. We had planned to take a brief afternoon break, and I still want to do that. Let's try and keep it down to 10 minutes. What I was hopeful as well is that I'm sure there are a number of questions that have occurred to you as the speakers this afternoon have been making their presentations. To the extent that you've already thought of a question that concerns you, perhaps you might note it on a piece of paper and hand it to me, because what we want to try and have is a very effective question and answer session at the end of the program in order to deal with what I'm sure are several interesting views that you have on what you've heard. So if we could just, my watch says we're about 4:45. We'll be back about 5 to 5. We'll wrap up a little earlier than we anticipated. Thanks very much.